And we have right here the mediation through the punong barangay. So what if any of the involved parties is incompetent or a minor? Well, he or she should be represented by legal guardian or next of kin who is not a lawyer. We all know that lawyer is not allowed to appear in barangay hearings. Can I mediate cases involving cooperatives or people's organizations operating in my barangay? So the answer to this one is no. A juridical person or corporation like a cooperative cannot file a complaint. Only natural persons can file a complaint in the barangay, and any case involving cooperative or people's organization can go directly to the court without going through mediation or conciliation proceedings. So what are the cases under the Katarungang Pambarangay? So all disputes, civil and criminal in nature, where parties actually reside in the same city or municipality, are subjected to proceedings of amicable settlement. And there are cases that fall under this jurisdiction. So what is the jurisdiction of the Katarungang Pambarangay? So these are the cases that is being handled. So to amicably settle cases within their respective barangay, it should be punishable by imprisonment not exceeding 1 year or a fine not exceeding 5,000 pesos. And what are some of the offenses punishable by the revised penal code, cognizable by the Lupon? So crime against public order, specifically alarms and scandals. So that can be settled in barangay. For crimes against public interest, use of false certificate, Article 175. This can also be settled in barangay. Another is concealing one's true name and other personal circumstances. This can also be settled in barangay. And we have here crimes against person, physical injuries committed in tumultuous affray, that can also be settled in barangay. And thigh physical injuries and maltreatment. And crime against security, as long as it is known as other forms of trespass. And to summarize, on the left side, these are the cases under Katarungang Pambarangay. And here also on the right side.
Hello, good morning.
And also, these are other cases under barangay. So these are exempted in Katarungang Pambarangay aside from that of a juridical person or corporation. So offenses involving government entity, and if offenses also with maximum penalty of 1 year and exceeding fine of 5,000. So these are cases cannot be handled by the Katarungang Pambarangay. And also offenses with no private party, just like littering, gambling, jaywalking, public scandal, vagrancy, and prostitution. And also real properties in different cities or municipalities. Disputes that need urgent legal action, like labor disputes, land disputes, and action to annul a judgment upon a compromise. So these four are some of the cases that are exempted in Katarungang Pambarangay. And what will be the first step in mediating cases? Well, the complainant, with the help of barangay secretary, will fill up the KP Form 7, and there is a filing fee for this, and that is paid to the barangay treasurer. And also, it's very important to note that no individual can go directly to court or any government office for adjudication of his or her dispute with another individual, especially if the matter is within the barangay jurisdiction. So here is an example of KP Form 7. It's a complainant's form, and this must be filled by the complainant, and after filling out all the information, a corresponding filing fee will be paid to the barangay treasurer. And we have here the question. You mean the concerned parties must go through the Katarungang Pambarangay? So yes, except when the parties personally confronted each other and settled their dispute. But if not, they should go through the conciliatory proceedings, or else the courts can simply dismiss for lack of cause of action or prematurity. So before filing the case into the court, if it is a jurisdiction of the barangay justice system, it must be first settled there. And are we not acting like a court and the lupon as judges? So basically, the barangay is not a barangay court, and the lupon are not considered as judges. After the complainant has paid a filing fee, what is the next step? So within 3 days, the barangay captain or the barangay should issue a notice of hearing to the complainant and summon the respondent, both of whom should appear in the barangay. And here is an example of KP form number 8, or notice of hearing, that will be given to the complainant. And what if any of the parties failed to appear simply without justifiable cause? So the case will be dismissed. If the complainant cannot appear before the barangay without justifiable cause, the complaint will be dismissed. The same goes with the respondent if he cannot also appear without justifiable cause. Counterclaim will be dismissed and will be barred from filing in court and be punished for indirect contempt of court. And this is an example of a KP Form 9, summon for the respondent. So this is issued to the respondent. So on the left side, here's the front page, and on the right side is the back page of the KP Form 9. So we have right here, what if both of them appear? How will I resolve the issue? So as a barangay captain, this is how you will resolve the issue. So it says right here that you will not resolve their case, but you will just help. So basically, you're just a facilitator or a mediator. You'll just listen to them carefully and help them find a solution within 15 days. And if the respondent does not appear, the case will be referred to the pangkat ng tagapagkasundo. So now, before I ask further on the pangkat, as the punong barangay, what will I do in handling their case properly? So before the actual mediation, it is necessary for you to know the parties involved and their differences. So it's very, very important that you at least have the background about what the issue is all about and who are the parties involved. What will I do? Is there a set of rules to be followed? So when it comes to the conciliation proceedings, you could start the process with a prayer. Then after that, you give both parties the time to explain their side without interruption. You ask questions for clarification, and also you have to get those both parties involved when it comes to getting a solution for their dispute. You're just basically there to facilitate the process. And it is a very tedious process. Yeah, it can be hard sometimes, and it needs a great deal of respect and listening. So as a barangay captain, you're not the judge, you're just there as a facilitator wherein both parties could find a solution to their dispute. So if they agreed to have settlement, should be put into writing the terms and condition? Yes. So once there is already an agreed settlement about their dispute, you really have to put it in writing. And it should be in a language or dialect known to both parties. And this is an example of, this is KP Form 16, or the amicable settlement form. So when we say amicable settlement, it's an agreement reached during mediation and conciliation proceeding. So at this time, once both parties have already looked for the solution of their dispute, this is the term used, amicable settlement. Then how can we be ensured that the agreement will be complied? So after 10 days, the settlement will be executory and it has the force and effect of a decision of court. What if any of the disputant was forced to come up with a settlement through fraud, threat, or intimidation? So if that happens, in that case, any party can protest the settlement within 10 days. For after 10 days, the settlement will take effect. How can the respondent comply with the settlement? So he or she can voluntarily comply with the settlement within 5 days. However, if he or she fails, then we can take his or her property as prescribed by law, and that will be discussed further with the barangay captain. What if mediation fails and no settlement is ever reached? Is there any way that the parties can settle their disputes? Yes, of course. The culture provides quite a number of ways of resolving dispute in barangay level, and one of this is resolving through a group of conciliators known and respected by both parties, and it is called as pangkat ng tagapagkasundo. And here is the conciliation through the pangkat ng tagapagkasundo. So, what if I have done my best in mediation, yet the parties have not come to an amicable settlement? Can they now elevate the case to the court? So, no, the parties still have to go to the conciliation proceedings. So, basically, the first step in settling disputes in barangay is to have a conciliation with the barangay captain. And if the dispute is still not settled, then it is elevated to the pangkat ng tagapagkasundo. So, what is the process of conciliation? As a punong barangay, you will constitute the pangkat ng tagapagkasundo within 15 days from the last day of the mediation proceedings. And before that, how does conciliation differ from mediation? Mediation and conciliation process are the same, except mediation is done by the punong barangay, while the latter is done by the pangkat headed by a chairperson, just like the mediation. And the chairperson is selected among the Lupon members. So when we say conciliation, it's just merely intervening between two or more contending parties in order to prevent or put an end to dispute without an agreement to abide by the decision of the conciliator. So who can be members of the pangkat ng tagapagkasundo? So there are 3 members who will come from Lupon and will be chosen by both parties, the complainant and the respondent. And we have right here the KP Form 11. It's notice to choose the pangkat member. And we have another, the KP Form 10, or notice for constitution of pangkat. So what if the parties fail to agree on the pangkat membership? Well, as the Lupon chairperson, the barangay captain will determine the 3 members by draw lots that will be distributed to the members of the pangkat. So, after the pangkat members have been chosen, what will they do? They shall elect among themselves a chairperson and a secretary, and the Lupon secretary shall turn over all records of a case to the pangkat secretary for the pangkat to study. So, similar to the membership of Lupon, can we also disqualify and fit members of the pangkat? So, when it comes to relationship bias, interest of other similar grounds discovered after the constitution of pangkat can be grounds for disqualification of pangkat member. So, the pangkat shall resolve the matter by a majority vote. And we have the section 404, talks about the pangkat ng tagapagkasundo. There shall be constituted for each dispute brought before the Lupon. So, pangkat ng tagapagkasundo, this is a conciliation panel which consists of 3 members. So, these 3 members are coming from the Lupon who were chosen by both parties, the complainant and the respondent. So, we have here, we've already discussed that should the parties fail to agree on the pangkat membership, the same shall be determined by lots drawn by the punong barangay. And how do we fill the vacancy of pangkat? So just in case the pangkat decides, or if the pangkat decides to disqualify any of its member, the party should agree on a common choice for the replacement. And if they fail to agree, the Lupon chairperson shall fill the resulting vacancy by drawing of lots. And during the first meeting, what is the immediate goal and how does the pangkat proceed with its task? So the pangkat shall meet to hear both parties, explore possibilities for amicable settlement within 15 days. The same with the mediation with the barangay captain, that the barangay captain is given 15 days. So for pangkat ng tagapagkasundo, they are given 15 days to reach an amicable settlement for both parties. And it can also be extended for another 15 days in a meritorious case and issue a subpoena of witnesses whenever necessary. So this is an example of KP Form 13 or the subpoena letter. What if any of the party fails to appear before the pangkat? So the Pangkat chairperson shall set a date for the absent party or parties to appear before him to explain the reasons for his or their failure to appear in the hearing. So it's just giving an explanation on the absence during hearing. And we have section 406, the character of office in service of Lupon members. So the Lupon members, while in the performance of their official duties or on the occasion thereof, shall be deemed persons in authority as defined in RPC. So if they are doing their responsibility as Lupon members, so they are persons in authority. And what if it was found out that their reasons for not appearing before the Pangkat was unreasonable? So if it's unjustifiable, if the Pangkat chairperson finds after hearing that a failure to appear of the complainant is without justifiable reason, he shall. So without justifiable reason, basically the complaint will be dismissed. And also, there will be a direct issuance of an attested certification to bar the filing of an action in court or any government offices. Apply with the local trial court for punishment of the recalcitrant party for indirect contempt of court. When we say recalcitrant, it's having an uncooperative attitude toward authority or discipline. And this is a KP Form 18 or the Notice of Hearing for a complainant, in case it will not provide a justifiable reason for non-appearance. And for the respondent, on the other hand, the Pangkat shall dismiss the respondent's counterclaim and also direct the issuance of an attested certification to bar the filing of respondent counterclaim in court or government office. To bar the filing of respondent counterclaim in court or government office, so he need to fill up the KP Form 20. Okay, and this is KP Form 19, Notice of Hearing for Respondent for failure to appear, and also to file complainant's action in court or any government office. The KP Form 20 must be filled out. So KP 20, this is certificate to file action. So on your right side, this is sample certification to file action or CFA. So what happens next if the Pangkat is successful in the conciliation? An amicable settlement shall be put into writing in a language or dialect known to them, and it's attested by the Lupon chairman or the Pangkat chairman. So it has the force and effect of the final judgment of a court after 10 days from the date of amicable settlement was made, unless there's a protest or repudiation of settlement is made. So when we say repudiation, it's like rejecting the terms and condition of the settlement. And the Pangkat secretary shall prepare a transmittal settlement to the appropriate court and fills up a transmittal form. And what another one? It's just the same. Yeah, when we say repudiation, act of rejecting the validity or refusing to accept the terms and conditions of the agreement. So how can the amicable settlement in Pangkat be executed? The amicable settlement has the force and effect of a final judgment of court upon expiration of a 10-day period of repudiation. And this may be enforced by execution by Lupon within 6 months from the date of settlement, and after the lapse of such time, the settlement may be enforced by filing of motion in the municipal trial court of the place where the settlement was made. What if there was no settlement between the parties despite all efforts to conciliate? So certification to file action, that's the form number 21, shall be filled up, attesting that no conciliation or settlement has been reached, certified by the Pangkat secretary and signed by the Pangkat chairman. So the certification to file action shall be submitted to the corresponding court or government office for filing of an appropriate case. So the document that is needed for the parties to file the case in court, it's the CFA or certificate to file action. So this is an example of certification to file action. It's KP Form 21. It's coming from Pangkat Secretary. So how the settlement can actually be executed? The disputant must first file a motion for execution with Punong Barangay, and then the Punong Barangay conducts hearing on the date assigned by the movant, Date shall not be later than 5 days from the filing of motion. So this is an example of KP Form 25 or the motion for execution. So during the hearing, the punong barangay shall ascertain the facts for the non-compliance of settlement and strongly encourage parties obliged to comply with settlement. After the lapse of 5 days with no voluntary compliance, the punong barangay shall issue a notice of execution. So this is an example of KP Form 27 or notice of execution. And within 6 months from the date of settlement, the lupon through the punong barangay executes the settlement. So this is the time frame for the execution of the date of settlement. And the actual execution may be in the form of money, but in case of failure to comply voluntarily with the settlement, the punong barangay shall take possession of sufficient personal property of the party obliged, and the property can be sold and the proceeds applied to the amount. How can the property be delivered or restituted? Well, if the property is located in the barangay, the punong barangay shall oust from the property the person against whom the amicable settlement or arbitration award is rendered and place the party entitled in possession. And if the property is outside the barangay but within the same city or municipality, the punong barangay shall authorize other punong barangay to take possession and act in accordance with the preceding paragraph. And how can the sale of personal properties happen? So a notice of sale shall be posted in 3 public places for perishable goods immediately upon taking possession. The sale should take place within 24 hours. And for other goods immediately upon taking possession, the goods must be sold within 5 to 10 days. So these are the properties exempted from execution. But we have to take note that not all properties may be sold at an auction. Like in exemplary here, the debtor's family home, the tools and implements necessary used by him in his trade or employment. If it involves animals, especially this one, horses, cows, carabaos, and necessary clothing, household furniture, provisions for individual or family use sufficient for 4 months, professional libraries of attorneys, judges, fishing boat, like this and like that. So these are the properties exempted from being sold. So we have section 406 or the character of office in service of lupon members. The lupon or pangkat shall serve without compensation. So if there is sufficient fund, they will be given honoraria. And the DILG shall provide a system of granting economic or other incentives to the lupon or pangkat members who adequately demonstrate the ability to judiciously and expeditiously resolve cases referred to them. And the lupon members, while in the performance of their official duties or on the occasion thereof, they shall be deemed persons in authority defined in the RPC. The parties may at any stage of the proceedings agree in writing that they shall abide by the arbitration award of the lupon chairman or the pangkat. They will have such agreement to arbitrate may be repudiated within 5 days from the date thereof for the same grounds and in accordance with the procedure hereinafter. The arbitration award shall be made after the lapse of a period for repudiation and within 10 days after. The arbitration award shall be in writing in a language or dialect known to the parties, and when the parties to the dispute do not use the same language or dialect, the award shall be written in the language or dialect known to them. So these are the exceptions of the proceedings open to the public. All proceedings for settlement shall be public and informal, provided, however, that the lupon chairman or the pangkat chairman, as the case may be, may motu proprio or upon request of a party, exclude the public from the proceedings in the interest of privacy, decency, or public morals. And when it comes to the appearance of parties in person, in all Katarungang Pambarangay proceedings, the parties must appear in person without the assistance of a counsel or representative. So, basically, lawyers are not allowed in barangay hearings, and also for minors and incompetents who may be assisted, they must be assisted, or they can be assisted by their representative, courier, or next of kin, as long as they are not lawyers. And When we say lupong tagapamayapa, it is known as the Peacemaking Council. And we say pangkat ng tagapagkasundo, they are the Conciliation Panel. And if you do have questions, just feel free to ask me whenever we have a face-to-face class.